Hi everyone. As introduced, I am Aditya Mehta and I'm taking this particular session on documents, essentially the practice and procedures surrounding documents, how you prove a document. Obviously, a short session like this one will not be enough to cover everything that can be said about documents. Several books will not be enough to cover everything that can be said about documents. But this is sort of an introduction into how it really works when you're in a trial, on how to deal with documents and how to move forward with documents. Moving on to the documents. So now the first question that comes with documents is, why are documents important? Because especially in white collar crimes and in all civil disputes, there is usually a contract that exists that will tell you the truth of things at a certain point in time, that people decided to sign and execute such a document which contained this truth. And that tells you the intention of parties at the time. Because when a trial takes place 15 years later, the accused will claim that I meant to do XYZ. The defendant will claim I meant to do XYZ. But a document, if proved correctly, will state exactly what the intention of a plaintiff or a defendant or an accused was at the time of the execution of the document. So it's impossible to practice any kind of law without some fundamental understanding of how documents are introduced in court, at what stage they're introduced, and how they are finally proved. So we have to keep two separate procedures in place for civil and criminal law, but the proving of the document itself is largely similar because proof is governed by the Indian Evidence Act, which is different, which is the same for civil law as well as criminal law. There's no segregation of documents in that respect. So to begin, we'll start with the point in which documents come to the fore. In a civil trial, one has to look at Order 12 and Order 11, Order 12 and Order 13, which broadly talk about once pleadings have been exchanged, which is that a plaint has been filed, a plaint will be filed with certain documents annexed to it by the plaintiff. The defendant will respond with a written statement annexing his own documents. And after that, on or before the settling of issues, there is a stage of admissions and denials, which is that the defendant will be put on notice to either admit all the documents or deny all the documents. Similarly, the plaintiff will also have to admit the documents produced by the defendant or deny the documents produced by the defendant. Now, you don't have to do a complete admission. There is a difference between admitting that a document exists and admitting the truth of a document. For example, I see there is a participant here called Ashok. If Ashok and I enter into a contract in 2019 and we have a dispute in 2021 and Ashok has filed a suit against me, he may say that Aditya and I entered into a contract in 2019 in his plaint. In my written statement, I can say, yes, Ashok and I did enter into a contract in 2019, but it is not the contract that Ashok has produced. So I'm admitting that there was a contract. I'm not denying the existence of a document, but I'm denying the contents of the particular contract that Ashok has produced. So you can deny either the existence of a document, or you can admit that a certain document may exist, but the contents of that document are untrue as produced by the concerned party. This is the civil trial model, which is that a plaint has been filed, a written statement has been filed, and then parties are put to notice to admit or deny documents. Now we move to a criminal trial. In a criminal trial, as some of you may know, an FIR is usually registered by the police. The police usually investigate the FIR and then they file something which is called a final report under the Criminal Procedure Code, or a colloquially referred to as a charge sheet. This charge sheet is taken onto the court record and usually has most of the documents, or frankly all to a large extent, that the police must rely on. And then, as and when the witnesses are called, documents will be marked in evidence. Now, having understood when the question of documents arise, the question that you must have crossed all your minds is, what does marking a document in evidence mean? Simply said, no document can be considered in a trial if it is not given an exhibit number. Now, what do I mean by that? I mean that even if when we file a plaint, some of you may have seen drafts, some of you may have worked during internships, you will say exhibit A, exhibit B, exhibit C, exhibit D. That's all fine. That's what you have given it just for reference. But the court must mark a document as an exhibit when it is convinced that the document has been proved to a prima facie extent to even be considered. Now, then you must ask is, when does a court, what are the considerations for a court to mark a document as an exhibit? Does anyone have any guesses on what could be the considerations of a court before deciding to mark a document as an exhibit. There are three different things. So if you know all three, fantastic. If you can come up with any one, any two, and it's okay if you're completely wrong, I'll correct you and I'll make a little fun of you at the expense of everyone, at your expense, so that everyone else is entertained. Any contract, any document has three things that have to be proved. One is that the document actually exists. That is, the contents of the document are what is written. For this, you'll have to produce the original document, primary evidence, ideally. The second thing that has to be proved is that the document has been executed. How do you prove that it's been executed? You have to identify the particular signature. That is, if I am the witness and I am proving a document, I will have to state that this is a contract. I am producing the original contract. That's one. The second is, it has been signed by me. I obviously recognize my own signature. Then I've proved the second aspect, that the document has been executed. And the third aspect is the truth of the contents of a document. Now, there is a difference between proving that a document in its original exists and that the contents of it are true. And I'll give you a very simple example. Let's say there is someone called Raju who I really dislike. Let's say I write a letter today I write a note today in a diary with my friend, with some other friend of mine, where I state Raju is a complete idiot. He has an IQ of 20. He can't do basic mathematics. He can't basically apply his mind, and he's extremely foolish. Now, if I sign this letter and I put it somewhere, tomorrow, if I go to court and I state, produce the original letter, the first part is complete. The contents of the document exist. I identify my signature. Yes, that signature that is Aditya Mehta's signature. But the third aspect, how does one prove the contents of a document? And then I will have to state that, yes, I have personal knowledge of Raju. Raju is completely stupid and idiotic. I have several times had several conversations with him and he's unable to basically apply his mind. You understand what I'm getting at? Now, this is a bit of a comical example, but let's say you and I enter into a contract, and it's a business contract. Me and Ashok are entering into a contract, and I tell Ashok, in the contract, it is written that at this point in time, Aditya, the seller, has in his custody 500 bags of wool, and Aditya is willing to sell you 500 bags of wool for 5,000 rupees, and you pay him 5,000 rupees. Now, Ashok and I enter into it. There is a dispute between Ashok and I. I cannot come to court because I'm busy somewhere. My brother, in whose custody I left the contract, tries to prove this contract in court. So he produces the original contract, which is not disputed. Therefore, the contents are proved. He identifies my signature because he's my brother. He knows Aditya Mehta's signature. So he says, yes, this is the signature. This is Aditya Mehta's signature. I identify it. So he has proved the execution of it, but he cannot possibly testify to the truth of the contents of that contract. He doesn't know how many bags of wool that I had, right? So you're understanding the three levels at which documents have to be proved. The first is that the document exists and its contents are as indicated in a paper. This is usually done by producing the original. The second is that the signature is authentic, or the handwriting is authentic if it's a handwritten document. And third is that you have some personal knowledge of the contents of that contract, and therefore the contract speaks the truth. If there is a contract about the intention of Aditya Mehta, nobody but Aditya Mehta, like every contract you must have read has formal recitals saying the parties intend to enter into a long-term agreement. Only the parties will know if the parties wanted to enter into a long-term agreement. So you'll need to prove the contents of that document as well. Now, why is it that my brother cannot prove that I had 500 bags of wool at the time? Because he may not know how many bags of wool I have at the time. And in cross-examination, the other side will bring this out. That how do you do business with your brother Aditya? No. What is your profession? I'm a chartered accountant. Do you regularly engage in Aditya Mehta's business affairs? He'll obviously say no, because he's busy as a chartered accountant. Then how did you know at the time that Aditya had 500 bags of wool? He would not know. So you understand how documents have to be proved in a threefold fashion, at least to the critical aspects, which is that the original document has to be produced except in certain circumstances, which I'll get into later. The second is that their execution needs to be proved by means of a signature that you can identify. And thirdly, that the contents of the document are true. Are there any questions at this point? Because this is actually the core of, this is something that many lawyers don't understand when they, they won't really pick up on the core of why documents need to be proved in such a manner. So now we know the three aspects of documents that need to be proved. And the question is, as I was referring to earlier, is if you prove these three aspects of a document, then the document is on a prima facie level, then the document is given an exhibit number. So for example, let's say I am the plaintiff, I'm examining my first witness. My first witness comes, he says, I'm producing this document. It is an original. I identify the signature, it is mine. I am personally aware of the contents of the same, they are all true. Then this document is marked as an exhibit. Exhibit 1 is the contract dated so and so. Now the question becomes, does that mean at the time of judgment, the judge has to rely on that document? No. It only means that prima facie, this document has been proved. Therefore, I have marked it as an exhibit. But the defense can make arguments as to why that document should still not be relied upon. And that is the prerogative of the defense, which they will do in two ways. One is in the cross-examination stage and the other is in the final argument stage. The only marking of documents only means that on the face of it, these three aspects that we discussed have been proved. Therefore, this document is worthy of the consideration of the court. And then at a later stage, while writing its judgment, the court will decide on whether to rely on this document or not. You understand the difference? One is of admissibility. If these three aspects are not proved, the document is not admissible only. The court will not give it an exhibit number. It cannot be relied upon by the court. But once it is admissible, once these three aspects have been proved, then the question becomes whether the court should rely on the document or not. Is there any question? Have you all understood the difference between admissibility in these aspects and then whether the court relies on it or not? Any doubts? That's great. Now, having understood how documents are proved in this fashion, we move to the second stage, which are what are the kinds of documents and evidence that exist. So if you remember, I had stated that the first part, to prove the contents of a document, you have to just produce the original document. Does this mean that in all circumstances you have to produce the original? In theory, yes. If you don't produce the original, the document cannot be marked as an exhibit unless you come within the purview of certain sections of the Indian Evidence Act, which explicitly allow for secondary evidence. If you look at section 65 of the Indian Evidence Act, it says cases in which secondary evidence related to documents may be given. Secondary evidence can only be given, for instance, when a document is lost. And then you have to prove that you lost it by making a statement that, yes, I shifted houses, I can't find it. Or when a document has been destroyed, or because of a fire, or when a document, for example, cannot be, when a document is what is in the possession of someone from whom you cannot recover it. For example, if I am the plaintiff and the defendant has the document, I gave him a notice to give me the document. He refused to give me the document. Then you can prove it through secondary evidence. Secondary evidence is basically like Xeroxes. Essentially, in the 21st century, usually your secondary evidence is in the form of Xeroxes. So in those circumstances, you can produce a Xerox copy to prove the contents. But the Xerox has to be created as per a mechanical process for a contract, for example. It cannot be, I wrote down roughly what was written on the original and therefore this is a copy. No, it's a mechanical process of production. I'm not going to get into the details because it's something you can read in the Bare Act itself. So where we're at is that primary documents are essentially required in all circumstances. In certain situations, you don't require primary documents. Because of certain exigencies, like you've lost the document or the document is not in your possession, it's with an adverse party. In those circumstances, you can produce a secondary evidence that is a Xerox copy, essentially, and certain other kinds which are mentioned in the Act to prove the contents. After that, you'll have to prove the execution, which is largely by identifying the signature and stating that this is my signature. And finally, you have to prove the truth of the contents of the document, which is where you will say, yes, I was aware of these facts. These facts did take place and therefore they have been captured in this document. Any questions so far? All right. I have a question. So the dispute that is taking place is with respect to a contract that was entered into by my mother. She entered into a contract with a builder. My mother is currently quite ill, so she can't come to court. So I go there and I prove the contract that she entered into with the builder. And my statement in court is as follows. This contract was executed by Niti Mehta. It was signed by my mother, whose signature I recognize. This is the original contract. Is this document proved or not? Anyone with an answer? No? Okay. The answer is no, because I cannot prove the contents of that contract. Nothing in my statement indicates that I know that the contract was entered into by my mother, that I know the various contracts that she enters into, that I'm aware of details like this and that. And therefore, even though I've proved the contract, the contents of the contract by producing the original, even though I have proved the execution of the contract by identifying my mother's signature, I have not proved the truth of the contents of the contract because I do not know the truth of the contents of the contract. I have no personal knowledge of the same. I hope that some of you had come to that conclusion at least. Now, one thing that you should know is that the Indian Evidence Act makes a differentiation between public and private documents. Now, why does the Indian evidence, what are public and private documents will be your first question at this point. So public documents are essentially documents which are created by a public official in the scope of his official duty. Private documents are any other documents, which is basically like a contract entered into between you and me. That's a private document because it's completely private. It's between two individuals. A public document would be perhaps a survey done by the collector of a particular district. And then the collector of the district finally creates a summary of how much money he's giving to which farmer in the context of compensation, etc. So public documents can be proved by means of secondary evidence. You don't have to produce the original public document. Can anyone think of a reason for why that is done? Whereas private documents, like the contract between Ashok and me, has to be produced by me. Does anyone know why that difference exists?
Okay, so public documents are in the custody of a public officer, and private documents are generally in the custody of the private person. So, in order to produce them, the person itself has the possession of that, so he can produce. But in case of public documents, the possession is in the custody of government. So basically, we cannot get the original one, but definitely we can get the certified one. So
Absolutely. She's absolutely right. I think. Thank you. Thank you so much. So the answer is, like Janelle said, and I'm just going to recapture it. She actually explained it pretty well herself, is that we as private citizens will have difficulty getting a government document in original out of the government. They will not give it to us because they need it for their official purposes. And that would make any litigation difficult because we need to prove that document, but we can't produce the original. And like she said, therefore, in law, in fact, the Indian Evidence Act explicitly states that a certified copy of a public document is admissible directly. And what does a certified copy mean? A copy given, and it's written in section 76. Every public officer having the custody of a public document, which any person has the right to inspect, shall give that person on demand a copy of it, which shall be sealed under his official name and title. And such a copy shall be called a certified copy. So in this manner, a public officer can give a certified copy. And since the presumption under the Indian Evidence Act is that public officials in their official capacity always act in a manner that is bona fides, the court will state that this is a certified copy of a public document. Therefore, I can rely on it even though the original has not been produced. Whereas, like Janelle beautifully stated, if two private individuals have a contract, we're supposed to have the contract with us. And since we are private individuals, even if we say this is a certified copy signed by me on my name, the court will not trust us because there's no presumption that private individuals will act in a bona fide manner. In fact, if any of you ever do get into any litigation, you will realize that private individuals never act in a bona fide manner. They will do anything to win a case and produce any document that they may have created in the backyard of their house completely fictitiously. So the Indian Evidence Act recognizes that, we can't trust Indians essentially. And that is why the Indian Evidence Act makes some leeway for government officers, but not for any private party who is part of a dispute. Is there any other question? Nina, did you have anything else to add when you put your hand up?
Yeah, actually, I wanted to say that even there is a leeway, but as you have rightly said, if we actually inquire that I want this document for so and so purpose, we can always get in a copy. And another part is that all public documents you can access these days from government websites itself. They have their own databases from where you can get it. So you don't need to actually have it in a form wherein it has to be original. just in a copy of it, you can submit it to court and court will accept, because it can be easily traced back and it authenticity can be authenticated very easily. So
See,
that's
Nina, just to sort of address that, I mean, you're right. You started out correctly for sure that we can get government documents from the government and therefore there's no issue. But the difficulty in what you're suggesting about getting them from government databases, no, is that even if you download it from the government database and print it out on your printer, how does the court know that you haven't photoshopped it in the middle? So that will not be reliable because it is not a certified copy. A certified copy is what section 74 to 76 allow for a public document. So you're right that you'll have to maybe get one from the government officer through his certification. But in principle, you're correct in that they are available in the public domain and can be accessed through government officers. And therefore, there is an exception, sort of a leeway given by the Indian Evidence Act.
So I have this question that whether documents that we get from RTI, are they also certified documents, or can we use them in court?
So this is a fantastic question. Actually, I really wanted to ask this question myself because I was like, this is what I thought. I'd give you a little background. And honestly, Weber, the answer is I've written an article on this and it was published in a journal and I'm fighting a couple of cases. The case law on this is very mixed up. There are high court decisions which allow for RTI documents because like you said, and you're absolutely correct, it's that what is an RTI? It's like let's say in an RTI, I apply to Khar police station and I ask Khar police station, you give me a copy of how many cases are pending against 3-4 people. I name them. If Khar police station in a reply to my RTI says, I have checked the records and 4 or 5 cases are pending against 3-4 people and they give me that response in the RTI, then my argument would be that this response is about public information created by a public officer in his original duty, And if he's given me a certified copy, if he's given me copies of all those FIRs, which under the RTI, which are pending against those people, then those are certified copies of public documents, which are FIRs, and therefore they should be admissible in certified copies. That is my argument. There are a number of courts that have accepted this argument. For example, there's a judgment of Justice Badar, which says that FIRs are public documents. There are a couple of documents in the Madhya Pradesh High Court, which have also allowed for this. But there are some conflicting judgments which state that what an RTI officer does is he takes a document. See, now an RTI, for example, every government department has one officer who handles the RTI aspect of things, right? So when that RTI officer takes a document, he just, let's say I asked him for an intimation of disapproval. I asked the BMC, give me a copy of an intimation of disapproval. That's a document that's used in construction and they may or may not give it, but I asked for it. Now, actually, the officer who signed that intimation of disapproval doesn't give me the copy. Some other RTI officer of BMC goes to the department of the BMC, finds that document, takes out a Xerox, signs it and gives it to me under RTI. So the court has held there that the officer who gave me that certified copy is not aware of the contents of the first document. And therefore, it should not be admissible. This is a very complex area. There are arguments both ways, and we will hopefully see the Supreme Court settling it once and for all in the near future. But I think that's a fantastic question. And my argument is in complete agreement with you that if an RTI officer gives me a document, he's given me a public document, which he has certified to be true, and therefore it should be reliable.
Yeah, because I think that, so as you said that every public document has a presumption that
Exactly.
the government will not lie, or
Exactly.
they will not produce a fraud or a fraudulent document. Similarly, it should be a presumption in favor of an RTI document that when they are supplying it, they should be it should be relied.
You're absolutely right.
Yeah. Thanks.
So moving a little forward, there is now the issue. So the Indian Evidence Act was made before the 1900s. It was in the 19th century. And what has changed since the 19th century that would be an extreme reality today in terms of documents, especially in COVID when everyone's working from home? Can anyone take a guess?
Online documents?
Electronic documents. Absolutely. Thanks, Weber. Documents until the 19th century meant pen and paper. It meant you and I got together, there was a contract, we both signed them one after the other. But the question becomes, if you sent me an email, what is the original? Where is the original? The original does not exist. There is no pen and paper. That email never existed. It is a bunch of code in ones and zeros in binary on the cloud or on Google servers. And if I produce Google servers in the original, which is obviously impossible, even then it's of no use. Because you can't look at Google servers and say, "Ha, yaar, ye to email yaar tha, it's correct. That is the original." Because servers are unreadable to man. They need to be represented on a machine. So this created a unique situation because nobody could produce an original document. It is printed out from my email account with which I use on a day-to-day basis, and I do not tamper with it. It is believable, it is reliable, and there is nothing that has interfered with me taking on this email and producing the original in court. In this manner, electronic evidence is another exception, where since the original is difficult to produce, it may be impossible to produce, then you can produce a certified copy. Can anyone here think of an example where the original can be produced in the case of electronic evidence? It's a tough one, though. I understand. Okay, Jenna?
The pen drives.
Well, see, pen drive is a complex answer because a pen drive is not necessarily the original. For example, let's say I take a video of myself speaking in this call, right? And then I put a pen drive on my computer and I take that pen drive and I copy the video onto the pen drive. Is the pen drive an original or not? It's
Before
not.
copying, it was original.
Absolutely. So the answer is not the pen drive. I mean, you're on the right track though. For example, a video, if I take a video of myself playing cricket on my phone, that video on my mobile is the original.
Yes.
At that point, it is an original. I can produce this mobile phone in court. The court can take it and the court can see the video on my mobile phone. And that is an original.
Yes.
Yeah, Asmit?
Yes. So e-stamped documents can be produced as an evidence, in case if it is e-stamped.
If it is e-stamped, see, if it's, you mean by e-stamped, what do you mean? Are you talking about paying court fees online or is digitally signed documents? Can you explain a little more?
So if we execute a agreement with digitally e-stamped, if we do it e-stamped, stamping is done e-stamped and then we digitally sign, then I think it can be produced as a original document.
Well, see, how will you produce that document in court? Let's say me and you are on trial and you want to produce that document. What will you be producing?
We can attach a printout of that.
Attach a printout. That's what I'm saying. Then the printout is the copy, no? The original is what you executed on your computer.
Yeah, I agree. Okay.
You understood? That's that's where this gets messy. If you're getting a printout, it's not the original. The original is on the computer.
Okay. Okay, if both parties agree that this is original document and we both agree.
Then you don't need to prove it only. Then you don't need to prove it. Then you can produce anything. Okay. If the party has admitted a document, then there's no question of proof.
Okay, then the court will accept it if both parties agree that this is original.
Yeah, so a court will never deny something that both parties are admitting.
Okay.
The issue becomes that in litigation, you will find nobody admits anything. Chance pe dance. So you can never hope for that sort of luxury, unfortunately, whether you're going for the truth or not.
Okay.
Yeah, so that sort of ends it with electronic evidence. Can anyone think of another situation where an electronic evidence, the original will be in court? I've given one, which is, let's say you take a video on your mobile. It was used in a recent case.
So a screenshot?
On your mobile? Where will the screenshot be? On your computer?
A computer or...
So what will you have to produce in court then?
The screenshot itself.
How will you produce a screenshot?
A series of screenshots, perhaps, and then played somehow.
Played, but on what will you get to court is my question.
The printouts.
Then it's a copy again. But to engage with your example, if I took 5 screenshots of this call and I produced my laptop in court, then I've produced the originals.
Okay.
You understood the difference. So evidence is in 2 forms, by the way. Evidence is either oral or documentary. At the time of forming the Evidence Act, they didn't think of electronic, and we've continued in that tradition. So if a witness says something, that's oral evidence. Otherwise, even videos, screenshots, everything comes in the domain of documentary evidence with a slight subcategory of electronic evidence. So in that particular example, we'll have to produce the laptop in court, and in the laptop, the screenshots will be the original evidence.
So this will CCTV cameras footage require a 65B certificate?
So, I mean, I'll give you a good example of this. What the police usually does, no, and I've seen this in my personal experience, is that of course they need CCTV footage. CCTV footage helps sorting out a particular issue. You know, I mean, usually who's entered the building when a robbery took place, all of that. The police always go to the CCTV footage area, that whatever control room. They'll take a pen drive with them. they'll take a copy of the CCTV footage and they'll take a 65B certificate. So in that scenario, you will need the 65B certificate. But if you produce the original entire, camera along with the recording equipment, the manner in which it's captured, perhaps that would not require a 65B certificate, in my opinion.
Okay. And how to get a 65B certificate?
You can make one. You can make one on your own. Get it from the person who has control of the device. So for example, if you send me an email, I will take a printout of that email and I will say that I, Aditya Mehta, certify that this email was received by me on my Gmail account, which I maintain on a day-to-day basis. It's not prone to any tampering. I have not tampered with the same. I have taken a printout of the email dated so-and-so without tampering with it. This email can be relied upon by this court. Sign it. That is a 65B certificate. It's not rocket science. We don't need to make it more complicated than that. You read section 65B, it tells you exactly what the certificate has to say. And I think Akash has a question. It says a video recording in the public domain, like music, video, audio of an artist. See, Akash, the question becomes, how are you producing that music, that video or audio? Are you downloading it off YouTube? If you are downloading it off YouTube and then you are putting it on a pen drive, then you will need the 65B certificate, etc. Can service of notice by email be proved by 65B certificate? Yes, absolutely. You can prove the 65B. You can prove that I sent this email. It was from my computer. I sent it. It shows I sent to so-and-so email ID. What happens when the other party denies the receipt of the email? How I do this in my trials is I show that this party uses this particular email ID because he'll usually have sent some emails to my client in the past from that email ID. So I'll prove to the court that this is his email ID. He regularly uses it. I have sent this email. There is a clear printout over here showing that this email was sent by Gmail. Therefore, let him prove why he didn't see this particular email, because I have established my case to a fair extent. You break it down. No, you show that you sent the email. You prove that with a 65B certificate. You show that that is the correct email ID by showing other emails he has himself sent from that email ID, which are admitted. And then you say, look, that is his email ID. Google says it's sent. Let him prove it went to spam. I don't know if it went to spam, but why should it be presumed in his favor that it went to spam? And I proved that it has been sent to him. I think that's a good preliminary understanding of documents. Obviously, there's a lot more, and I think you all have realized that it's a complex area. But are there any other questions, anything else you all want me to discuss on the Evidence Act, any queries you all generally have? Because I wanted to broadly tell you what are documents, primary and secondary, public and private, at what stage do they come about, and how do you prove a document? If there's anything further that you want to go in depth into, I'm happy to do so, but I don't want to randomly pick up bits of the Evidence Act and go deeper.
So there was this recent case where a lady, I think in US or UK somewhere, she alleged that she was gang raped in the metaverse. How does this hold, and how would we prove any offense or any crime if it is taking place in a metaverse or some...
I don't think we can, at least the way the criminal code or at least the penal code is drafted in India, that a gang rape in the metaverse would constitute rape as defined. Unfortunately or fortunately, or I honestly, it's difficult to conceive of a bodily offense in a universe where bodies don't exist. But to your point, which is it need not be gang rape, it could be something like a cyber fraud where he stole my data on the metaverse, and that is a realistic possibility. In that case, how you would have to prove it is how you prove any offense. You'll have to prove what took place on the metaverse, either through videos or through your own account of what took place. If I state that I was at XYZ place in the metaverse, he came to me, he took my information from me, and based on that, he hacked into my bank account, my money went from my bank account, show that your money has gone. If you can make that chain, and then your testimony is reliable on all other aspects, and you can provide corroborative evidence like your metaverse account, the fact that you were online on a certain day, I think that would be how one would go about it. It's not inconceivable.
And similarly for a marriage, will the courts presume that a marriage took place when it took place by the two parties being on metaverse?
I think I know the news article you're talking about. No court ever presumes that a marriage took place. It has to be proved. So I would assume that they sent out evites on the metaverse. I would assume, I mean, I don't think that marriage would have any legal validity because there are Supreme Court judgments that say that a marriage requires, at least a Hindu marriage requires certain processes. So I'm sure those guys had a court marriage separately. But unless you can prove that the marriage took place by certain rituals or by a court marriage or anything, then the marriage would not have legal standing.
Yeah, I think interesting issues coming up.
I think I mean, the word metaverse means we know less than we can even really say. So it's not just in the legal space. I think it's in all spaces that people are confused. But
True.
I think this Zoom call and this class would have been very different if it were taking place in the metaverse. I think that's all from my side. If you'll have any other questions, I'd be happy to help. Otherwise, we can end this.
So Aditya, is there a difference between the practice, of producing documents in the lower courts and the high court?
I mean, it's a small difference. In lower courts, things are a lot more structured. In the high court, that they want you to give them a table with everything, and because they're busier. Essentially, they have a lot more going on. Whereas in lower courts, it's a little more mechanical. You produce the document. The court judge looks at it. He looks at what statements you've made to prove that document. He'll hear the other side. He'll just mark it. So to some extent, there is a difference. Whereas in the high court, they will require a draft statement of issues, and before they will even get into the question of these things. So there are some differences, but not, I mean, that would also vary from high court to high court. Like the Bombay High Court has its own practices, and I'm sure that would vary. Some courts, for example, like outside of Mumbai, I mean, outside of, states like Madras, Delhi, Bombay, the High Court doesn't engage in trials at all. So then there you would only go before the trial court. There is a question, whether plaint is a private document, as in criminal trial, charge sheet is a public document. A plaint is a private document or not. Actually, I'm not 100% sure, but my theory would be that once you file the plaint in a court of law, it's not a private document, because you can get a certified copy from the court, so that you can at least prove that the plaint has been filed by getting that certified copy. Can a certified copy of a public document be produced at the stage of trial, and will the court look into its admissibility? A certified copy of a public document ideally should be able to be produced at any point, in my opinion. Even though technically there is a stage for production of documents. If I produce this document and under the Evidence Act it's admissible and reliable without the need of any other evidence, then I think the court should take it into consideration.
Yeah. Thank you for giving one more opportunity to ask the question.
No problem. Happy to.
So if I produce a electoral roll of a colony through which I have and I've taken it from the website of the EC, Election Commission. And how do I now prove it in the court? Do I have to call
65B certificate? But you print it out from the website. Question is whether the website is, I mean, you'll have to prove where you got it from, which is the website of the EC itself. And you'll also have to give a 65B certificate for the printout.
Okay. Thank you.
Okay.